All right, sorry about that, guys. Had a little bit of an issue there, but we are all we're all good now. We just turn that off. My name is John Crump, and I am joined today by Flying Rich. Flying Rich is right here. So, yeah. Uh, hold on for 1 second here. I'm going to bring this up, and we're going to discuss what is going on because there is new documents filed in the auto key card case, which is the appeal filed by Matt Larassier, who is the attorney for Matthew Hoover, better known as CRS Firearms. What's up, Rich?
Crump, how's it going, man?
Not much. I freaking, for some reason, it's a say something else.
You hear me now? How's it going?
Yeah, I don't know. Something's going on with my.
It'd be nice if the StreamYard Studio gave you audio levels on screen. That would be cool.
Yeah, I don't know. Hold on. Going to.
You get audio levels when you're backstage, but once you go in, you don't see it anymore.
Yeah, for some reason, I don't really hear you too well.
No, Q10 hears me. FGM, how's it going, man? Let's see, who else we got? We got Kurt24, Johnny 3-Bar, The Sentinel.
Okay.
Sunday, Monday, Morning QB.
Something's wrong with my adapter, but I pulled it out halfway and now I can hear fine.
So. And we've got breaking news. Toby Hatch, how's it going? Johnny
I wouldn't say it's breaking news, but it is news. So,
news.
Yeah.
So you would categorize breaking news something that happened like within the last 2-3 hours, I would assume?
Yeah. This hasn't been breaking news. I just haven't had a chance to get to it, but I wanted to do this, and I figured we'll do it live because it is a court filing, and yeah. So let's go ahead and read it. This was filed, and this is using a lot of Cargill and other actions. So Rich will kick us off here.
Okay, so this is Justin. Is it Matt or just Justin?
It's Matt. The case was originally filed under Justin.
Oh, okay.
The appeal for Matthew Raymond Hoover. So let's just start with the arguments.
Okay, argument. New Supreme Court precedent makes clear that the case made by the government suggesting that the auto key card was a machine gun is inconsistent with the statutory definition, which this is critically important because they did a couple of things recently. Chevron deference.
Great, we'll get to that. Just read it, then we'll get to that.
And it cannot be the case that a malfunction inherent in the design of one of the most common semi-automatic firearms rifles in America results in a weapon that shoots automatically more than one shot. As explained infra, if the government's theory here can support a conviction, it must mean that every single AR-15 in America contains a receiver of a machine gun, and that possession of any post-1986 semi-automatic AR-15 violates blah.
61B. That right there, that's the Hughes Amendment that was attached to the Firearms Protection Act that went into effect back in the 80s. What they're talking about, you got to remember, the government never got the auto key card to function as a lightning link. What they got was hammer follow, which is a malfunction.
Review of the record, inspired by new precedent, also revealed an issue in the district court's holding with regard to its constitutional analysis in denying the motion to dismiss the indictment for due process concerns, which appellant briefly discussed in part two. The evidence relied upon most heavily by the district court in denying the motion for judgment of acquittal was a testimony of ATF Firearms Enforcement Officer Cody Toy. No evidence was put forth that the device manufactured by FEO Toy caused a semi-automatic firearm to fire automatically, as opposed to simply more than one shot. But FEO Toy admitted his creation induced a hammer follow malfunction, a malfunction that would be identical if a single part of an ordinary semi-automatic AR-15 was removed, worn down, or malfunctioned. And citing docs.
Okay, what they're doing here, I'm gonna tell you what he's trying to do. In Cargill, it said that a machine gun conversion device or a machine gun conversion device have to function as a machine gun conversion device per statute. They're saying that the way that they got the auto key card to function was actually inducing a malfunction and not causing the firearm to fire automatically, because it was a malfunction and it did not transform the AR-15 to an automatic machine gun.
Wow.
Oh, and this is where he's going to talk about it. So go ahead.
Okay. Cargill, and automatically
out there that I jumped ahead, but
as an independent element, Garland v. Cargill was a case of statutory interpretation, much like the instant one. Cargill examined the functional language of 584.5b that a machine gun conversion device must automatically cause a weapon to fire more than one shot through a single function of the trigger. Giving due weight to each word in that statute, Cargill held that it is not enough that a weapon fire more than one shot by a single function of the trigger. It must do so automatically.
So basically they're saying it doesn't do it automatically.
Based on dictionary definitions existing at the time of the NFA's passage, automatically as an adverb means having self-acting or self-regulating mechanism. Beyond that, the government's own interpretation beginning in March 26, 2019 defines automatically as it modifies, shoots, is designed to shoot, or can be readily restored to shoot as functioning as the result of a self-acting or self-regulating mechanism. Giving full effect to the words of the statute, the word automatically must mean that the firearm that shoots more than one shot by something other than self-acting or self-regulating mechanism, or which happens to incidentally fires more than one shot as a result of a malfunction, is not a machine gun as defined by 584.5b.
Yeah, and remember, the Toy, which was the ATF guy, the examiner, he got it to fire because it caused hammer follow, which is definitely a malfunction.
And there's further detail on it. AR-15 cartridges are specific, 5.56, 223, are specifically designed with hardened primers that if a hammer follow occurs, it will not set the round off. And one of the things that was not stated or brought up in Matt Hoover's case was whether they loaded specific ammo with light primer cartridges that would go off with hammer follow.
I have seen regular cartridges go off with hammer follow, though.
Okay. Few cases have dealt with bifurcate analysis of whether more than one shot came automatically, but the common meaning of terms and earlier cases provide insights. Staples ultimately resulted in a landmark Supreme Court ruling on mens rea, but the courts below dealt with an AR-15 without an automatic sear, where the government was able to induce hammer follow, United States versus Staples. Okay. In Staples, ATF oiled the firearm, changed its bolt carrier, and loaded it with soft primer ammunition to encourage hammer follow malfunction to result in the discharge of multiple shots.
Basically, what they did is they rigged it so it would malfunction.
Additionally, the government rested on the firing of multiple shots without providing evidence of any automatic function over defendants' appeal to objections. The 10th Circuit's analysis in Staples, later reversed by the Supreme Court, enabled it to avoid the broader question of whether a weapon that malfunctions can constitute a firearm under the NFA. However, the Supreme Court's ultimate decision in Staples makes it clear that actual knowledge of the characteristics of a firearm, making it subject to an act, is required to sustain a conviction. In Cargill's clarification that automatically in more than one shot are not redundant, but are actually separate elements, it is necessary that the government plead and prove that the device induce more than one shot automatically by way of a single function of the trigger. Here, the only evidence provided admits something created by the government witness induced a malfunction, a firearm which incidentally or accidentally fires more than one shot cannot rationally be said to be firing automatically. The malfunction caused by FEO Toy's creation is best understood against the backdrop of how an AR-15 is designed to function automatically.
FEO means firearms, or like a firearms examiner officer, examination officer.
Below, the following image reflects the fire control group components and moving parts of the action of a fully automatic AR-15, such as an M16 locked position, ready to fire. These parts of the action and fire control group are critical to the function of the rifle and responsible for the firing sequence. Pulling the trigger releases the hammer from the sear on the front of the trigger, allowing the hammer to release its stored energy and strike the firing pin. As the ammunition cartridge fires, pressure causes the bolt carrier group to travel rearward, unlocking the action as the
We all know how it works. So I just want to skip all this because of it. All right, just
Okay.
I'll just here.
So drop-in auto sears, such as those the government alleged the auto key card to contain or depict, imitate the function of an automatic sear shown above. As the government's witness testified, the timing of
Sorry.
I don't know where I am. The timing of the automatic sear with the tail of the bolt carrier group is critical for a drop-in auto sear to function the way the original designer intended it to. However, that is not what happened with Mr. Toy's creation. Rather, Mr. Toy induced hammer follow. It firing more than one shot was occasional. I was getting some hammer follow, which caused some of the test fire not to work. Mr. Toy further stated that the hammer follow he induced was identical to how an ordinary semi-automatic AR-15 would function if the disconnector were removed or damaged. To illustrate, following depicts a typical semi-automatic AR-15 functioning, beginning with the bolt locked and ready to fire.
Yeah, there's been a bunch of cases where if you can't see it, but do you see that little like ledge where it connects and disconnects. If
Mhm.
that gets worn down, the rifle will cause hammer follow because that is worn down.
As the bolt carrier group travels rearward, recocking the hammer, the disconnector retains the hammer in its rearmost position until the bolt is locked and the trigger is released, ready to fire another cartridge when pulled again.
Yeah, so that where it's circled at, that can get worn down and not disconnect. So it's just so if like this is a good example right here. Imagine if that little ledge there was
Mhm.
worn down enough so it doesn't connect. You'll get a hammer follow.
The above reflects the functionality of each of the 20 plus million semi automatic AR 15s estimated to be in American hands. The hammer follow induced by FEO toy is equivalent of removing or disabling the AR 15 disconnector, which would require either the part's failure or drifting one pin on any semi automatic AR 15, which toy testified, depending on the skill level, would take a matter of minutes. A hammer follow malfunction is depicted below.
Yeah, so basically right here it shows you with the disconnector removed, or you can just leave the disconnector in there and just take a little Dremel and not saying you should do that, but I'm just saying
Yeah,
that's
this was not advice.
yeah. I'm just saying I'm explaining what he's talking about. All right.
Critically and antithetically to functioning as either semi automatic or automatic weapon, nothing retains the hammer while the firearm is experiencing hammer follow malfunction, as Mr. Toy testified in a hammer follow situation. As the bolt carrier group travels forward, the hammer follows it, expending energy as the bolt closes and resting on the firing pin while the bolt is still unlocked rather than striking it after the action locks, rendering an additional shot an unpredictable malfunction, carrying with it the possibility of a firearm exploding.
Yeah, see, with like a true auto sear, it's regulated, so the speed is regulated. With the hammer follow, you lose that.
So it's
So
timing.
yeah,
Basically, it
it's
doesn't
time.
let the hammer hit the firing pin until the bolt face locks in the barrel extension.
Correct. With hammer follow, you don't get that. It's you can actually hit the bolt carrier. A lot of bad stuff can happen. It's not something that you want to screw around with. So this
The
shows you all the different ways.
appellant submits that it cannot be the case that a malfunction which Toy testified would cause the weapon to fire more than one shot occasionally that is possible in the event of a failure of a small metal part present on every single semi automatic AR 15 in this country equates to a weapon which shoots more than one shot automatically.
Because any AR-15 can get hammer follow just by
You could get
use.
worn out. You could have I know of cases where you get like a chip from a casing in
Yeah,
there
there was
and
like
you
a
get a
sliver of metal I wrote an article about, and they tried to charge some guy because a sliver of metal that wasn't placed there by him, it just sliver of metal somehow
accidental,
accidental got in there and
accidental and
caused hammer fire.
unintentional.
Yeah. So I wrote about a case like that.
As explained supra, the basis of the government's theory is that a hammer follow malfunction results in a machine gun. As FEO Toy testified, the device created simply defeated the disconnector. It did not function the way an auto sear or lightning link is designed to function, was identical with the simple removal of the disconnector, and the removal of the disconnector would require an AR 15 to be regulated like any other machine gun. As discussed supra, Part 1B, and as FEO Toy testified, a disconnector failure requires only the drifting of a single pin or the breakage or wearing of a single part, in contrast to the actual functioning of an autosear, drop-in autosear, or other machine gun conversion device for the AR-15. Hammer follow malfunction does not require any additional part or combination of parts to exist on an ordinary AR 15 with the simple removal or failure of one part without any modification to the receiver results in a hammer-follow malfunction. Thus, if the government is correct that the hammer-follow makes a machine gun, it follows that every semi-automatic AR-15 ever made contains the frame or receiver of a machine gun under 584.5b. Appellant submits that cannot possibly be the case. A weapon which fires more than one shot occasionally, sometimes accidentally, or as the result of a malfunction, cannot rationally be said to be shooting more than one shot automatically. Clearly, in drafting 584.5b, Congress qualified more than one shot without manual reloading with the adverb automatically for a reason. It avoids the application of gross criminal penalties to otherwise lawful yet malfunctioning firearms. This compounds the vagueness and lenity issues raised in the appellate's and amici principle, whatever.
Yeah, you have something called the rule of lenity. Do you want to explain what that is, Rich?
Sure, the rule of lenity says that any regulation or law has to, when it's ambiguous, has to be found for the people, not for the law. So
Yeah.
basically, reasonable doubt has to be given to the citizen.
Yeah. So the rule of lenity always falls on for the citizen.
Congress cannot punish felonies generally, according to every criminal penalty it enacts, must have some relation to the execution of power of Congress, like the power to lay and collect taxes, duties, imposts, and excises to pay the debts and provide for the common defense of the general welfare of the United States. U.S. I'm assuming Constitution, Act, blah, a law which attaches consequences beyond requiring payment to the IRS is a penalty, not a tax. The National Firearms Act, through which 5861E came, was passed and has been upheld by the courts expressly under Congress's taxing power. However, 18 U.S.C. 922(o) prohibits the possession or transfer of machine guns, however defined, not registered by May of 1986. As such, the United States refuses to register or accept tax payments for the transfer of machine guns made after 1986, necessarily as it relates to machine guns 922(o), either implicitly repealed 586(1)(i) or 5861(e)'s application of to the transfer of machine guns made after 1986 violates due process. Even the United States Attorney's Manual recognizes this constitutional shortcoming. Whoa! Section 922(o) of Title 18 makes it unlawful to transfer or possess a machine gun made after May 19, 1986. In addition, under the NFA, it is unlawful to manufacture or possess a machine gun without first registering it with the Secretary of the Treasury and paying applicable taxes, blah. As a result of the enactment, blah, the Secretary of the Treasury no longer will register or accept any tax payments to make or transfer a machine gun made after May 19, 1986, accordingly, because it is impossible to comply with the registration and taxation provisions in the NFA. Prosecutors should charge the unlawful possession or transfer of a machine gun made after May 19, 1986, under 922(o). Charging machine gun offenses under 18 U.S.C. A 922(o) instead of under the National Firearms Act. United States Attorney's Manual. Despite this, the government here insisted on pursuing appellant under 5861E. Appellant Hoover moved to dismiss the indictment, among other things, because his prosecution under 26 U.S.C. 5861E was not a valid exercise of the power of Congress to tax consistent with the due process clause. The district court denied this motion, citing U.S. v. Spoerke as foreclosing the argument, but this was a misreading of Spoerke, however you pronounce it. In
Yeah.
Spoerke, defendant
Yeah.
appellant was charged with making and
Okay. I just want to say 922R. I mean, 922
oh,
O is unlawful acts, which is that O states that it is unlawful, and this is not under the NFA. This is under a different law that was passed in like 1986 that says it's unlawful to register to make a machine gun, basically. So if it's not being prosecuted under, it's not under the NFA. So, yeah, a little bit different.
so do you want to scroll up?
Yeah, so it's basically 922.0. It's basically unlawful for to transfer or possess a machine gun unless it's made before May 19th, 1986. All right, so keep on going.
Okay. In Spoerke, defendant appellate was charged with making and possessing a pipe bomb without registration in violation of 5861F. And let's see, Spoerke argued that compliance with 5861 was impossible, but the court recognized this to be based on a false premise. No federal statute completely outlaws the possession of pipe bombs, therefore, their registration is not legally impossible. This case presents the opposite of Spoerke, which, let's see, situation 18 USC 922.0 does not completely outlaw the private possession of a machine gun made after 1986, and thus, regardless of whether or not an individual is a felon, compliance with 5861 is actually impossible. This court has not squarely addressed the issue of 5861E as an exercise of any enumerated power as applied to post 1986 machine gun. The 1995 case of U.S. versus Rivera was the closest examination. Both was dicta and concerned a
But that was
question
dicta and concerned, not questionable.
not before the court. And let's see, citing cases from the Fourth, Sixth, Seventh Circuits engaging with the issues. Circuits holding the application of 5861 to the possession, transfer of post 1986 machine guns to be unconstitutional are in the majority and much more developed than the minority approach, whose decisions are rooted in the Fourth Circuit case US v. Jones.
Yeah, so
Indeed,
basically, if you have a post 1986 machine guns, you're going to be prosecuted in 922.0 in most cases, and not 5861 in the NFA.
Indeed, even the Department of Justice has expressed agreement with the line of cases holding 5861 to be unconstitutional as applies to post 1986 machine guns and continues to counsel away from its use in the United States Attorney's Manual. Additionally, substantial developments have occurred in taxing clause analysis, which support appellant's argument. These are reflected in the more modern cases affirming 5861's unconstitutionality as a tax on machine guns made after 1986. Wow, whoever versus US, United States versus Cox, US versus Borns, holding that the NFA provisions no longer sustainable under the tax power, US v. Gamble. Let's see. It is hard to understand how any circuit could find such a conviction permissible when the provisions of the NFA have been totally eclipsed by Section 922.0. To the extent the government may argue 5861 may be complied with by completely avoiding machine guns, that does not save the statute's application here as a legitimate exercise of the taxing power. The United States can instead choose to follow its own manual and charge under 922.0 in cases concerning post-1986 machine guns accordingly. The district court erred in denying the motion to dismiss, and this honorable court should reverse the judgment and sentences in this case submitted Matthew Larassier.
Yeah. Okay. So, so this is definitely interesting. One of the things that the courts have done is they've always shied away from machine guns. They just do. I mean, just what they do. There's a couple of questions here I want to get to. Does he have the same lawyer? He does,
Yes.
Totally Town. And so did any of them function like a lightning link? And no, they did not. They got a hammer follow by jamming up the disconnector.
So, John, if your job was to make a lightning link out of an auto key card, would you try multiple times if you weren't successful, and then record and submit as evidence your best, closest success?
That appears what Toy did. You got to remember, he didn't cut in the lines either. He cut outside the lines.
In other words, if I took some material you created and just went off on my own in fabrication, and yes, that is the pièce de résistance.
Hey, Matt, if you want to come on, let me know. Just send me a text. I'll send you the link. But yeah, I did like the vaccine argument. That's what I was like to say.
So we did not get to that point yet. The interesting thing here is not only is Matt arguing like, hey, hammer follow blah, you didn't get this to work, but he's also gunning for machine guns to make them legal. He says, "Pop me the linko."
You have the linko, buddy-o.
So Matt Larassier and Matt Hoover's case could be pivotal in getting us machine guns.
Yeah, I do. I mean, there's all sorts of tax questions, but I do like how he did attack the taxing issue too in the 922.0 and stuff like that, because that's missed a lot. And
yeah, I think all of these, I think this is a very well written, well thought out, and it's like the chicken cordon bleu of get Matt out of jail. So there's a little tasty bit inside that could be real exciting. I would think, and please tell me if I'm wrong, that most of the time these things occur that lower courts do not want to give everybody machine guns. They're gonna maybe not rule on that section, but rule on like, hey, we'll let him out of jail. Is that the experience?
Yeah, criminal cases are funny like that, right? For example,
because I don't think any judge wants to make machine guns legal on their own, especially if they're not Clarence Thomas.
Yeah, there was a case recently where a judge ruled that machine guns were protected arms, but he only applied it to the plaintiff or the defendant.
The defendant. So it's not a globally.
That is 100% correct. Matt, I sent you the link. I don't know if you got it or not. But yeah, so I mean that's the thing. Hopefully one day the NFA will die totally. Hopefully a fast and swift death. We'll have to see.
So that case where they applied it to one individual, that machine guns are protected arms, could that be held as precedent for future cases?
I don't think it will be. And look who we have. The guy that actually wrote the brief.
Good morning, gentlemen. How are you?
Hey, how's it going?
It's going all right. I was glad to see you guys covering this. It's super important.
Yeah. So let's talk about the taxing argument.
Yeah. So the interesting thing is that we brought this argument down below. We also brought this argument in the Adamiak case, the Navy sailor who had the kind of parts kits. The Adamiak case, the government got to sidestep it because they also charged under 922.0. And so just to explain this to the audience, you generally, like if you have an SBR or whatever and you haven't paid your tax on it, there's only one way to charge you with a crime for that. And that is to say, hey, you had this gun, you didn't pay your tax, right? Those are the elements. And so you're guilty, right? You had the gun, it was less than 16 inches, and you didn't pay the tax on it. And how do we know we didn't pay the tax? Because it wasn't registered. The Firearm Owners Protection Act, though, FOPA, the reason why we can't have new machine guns is because there's another, not under Title 26, but under 18 USC, they passed a different law that specifically says no person can have a machine gun that wasn't registered before this date.
The Hughes Amendment.
Exactly. Which was never designed to pass. And that's one of the reasons why it causes all these problems. It was supposed to be a poison pill that would sink FOPA, but it didn't. And so what wound up happening is they try to keep, they'd be like, oh, you have a machine gun. And we know you had because you didn't pay the tax. So we're going to charge you under the NFA. But you cannot charge somebody for non-payment of a tax when you will not accept the tax payment. And so that's why even the U.S. government has agreed. Even the U.S. Attorney's Office has agreed, and so they wrote in their damn manual, "Do not charge under this." Right? That doesn't say. By the way, that doesn't mean that 922.0, that the Hughes Amendment is a good tax law. It's not, and it was still passed under the taxing power, so it is subject to a separate challenge, right? But this way, it's not, and like Rich was pointing out, you're not saying, hey, we have to, this is, if you agree with us, machine guns are totally legal for everyone, as much as we would like that to be the case. It says, you guys were sloppy. Why are you not even following your own manual?
Yeah, you charged them under the wrong thing.
Exactly.
Because you charge them with you're not paying a tax, but you also would refuse to take the tax. So therefore,
exactly. And in this case, they did not bring up 922.0 a single time. They didn't bring it up a single time. Unlike in Adamiak, they charged him under both the NFA and 922.0. And that was a mistake. And the government has admitted that was a mistake in the Fourth Circuit. So I don't know why the government keeps doing this, but they do this a lot. And in most of the country, it's agreed that you can't do this. It's only a couple circuits, and unfortunately, the 11th Circuit hasn't explicitly said you can't do this yet. But they also haven't held otherwise, right? They haven't said that the government can do this. And so that's why I'm hoping that the 11th Circuit will look at this and be like, okay, obviously, that's a mistake.
We got a question from Jordan Venro.
No, because the way that you have to have registration is the way the law is written.
Yeah,
but this is just a thing, and I think the main takeaway for the 5861 part of it, the NFA part of it, is that the government has all of these resources, right? So much more resources than any of the people that they are going after. How come they're being this sloppy, right? They're not even following their own guidance. They can't follow their own guidance on charging machine guns, and yet they want us to be able to divine what is and is not, right, a machine gun. I think it's pretty messed up.
Yeah, that is that is messed up. I've always wondered why they didn't charge them with 922.0.
Honestly, I think it was just a bonehead oversight, really. There's no other way to say it. And it's not like this is deep lore tax law analyst, right? This is it's in the manual. Like you saw it right in there. It says in black, right? Don't do this. But they keep doing it. And a lot of people get off in the freaking Ninth Circuit routinely. They get off on a machine gun charge because the government was too boneheaded to read their own manual.
So
what's the next step? When will we hear something back from the circuit court?
We do not know. So this should be the end of all of the briefing. Unless, the Supreme Court does something else interesting. This should be it. So the next thing we'll know is whether or not the court selects this case for oral argument. I think there's a pretty high chance that they do. But on the other hand, there's been so much briefing that they may just be like, you guys have fully discussed everything. We're going to decide this on the papers. Yeah. The government does get to reply to this. Their reply is due. There was a letter order on it. It's in like a couple of weeks. They don't have to, but they probably will. So that's the next thing we're going to see is we're going to see the government reply. I also thought it was interesting. I don't know if you guys looked at Irvin's lawyer filed a brief on this as well, which was interesting. Their argument was that we shouldn't look at Cargill at all, and I didn't really understand.
Yeah, I was gonna look at that. We're gonna review that one probably Monday or Tuesday.
It's only like one page, so
yeah.
There's a whole. It's only really one page of words, but it's just not yet. No, but it should be soon.
I hope so.
But yeah, what did you guys think of the machine gun analysis though?
I thought that was great. I thought that was really well thought out, and the legal precedents quoted there, and yeah, basically, it makes me so mad, and I'm sure you felt incredible anger also when it's like, you mean they induced hammer follow and Matt's convicted.
I mean,
and they just said it out loud, right?
Yeah, but hammer follow. I mean, like if the disconnector's worn, it can cause hammer follow, or you just take a little Dremel and go ding.
Right. It's a hard steel part, so it's brittle and it wants to fail in this fashion. They do. Like, go and look up, broken disconnectors. There's tons of manufacturers where it happens, and this is the symptom. So the thing is, though, and ATF has been saying this for a while. It's actually really interesting. We went back and found, like, this is part of the whole AR-15 M16 debate. We went back as far as we could to find ATF guidance on how should an AR-15 be configured, right? And you know what they said? The only official ATF guidance is you should have a Colt SP1. It says original style Colt SP1, and it says hammer, trigger, bolt carrier group. Actually, no, it doesn't say the bolt carrier. It says hammer, trigger, and disconnector. You know what's interesting about the first 2 years of production of the Colt SP1?
What's that?
An M16 hammer, trigger, and disconnector.
Yeah.
Oh.
Yeah. So it's literally what they're.
They got parts.
Yeah.
You can still buy, like M16 trigger, like at lower parts kits.
Yeah, and anyone can own it. It's free. But the biggest thing here is, like, and this is what I just wanted to make sure it came across, is that if it's the case, right, as this gentleman testified, that if you take out the disconnector, it's a machine gun, right, period. That's what he said. What's the difference between the receiver of an AR-15 that you broke the disconnector on and the receiver of a normal AR-15?
Or an AR-15 that you assemble without that part.
Yeah, it's the same receiver, right?
Yeah.
So it has to be. If that's true, it must be a machine gun. It has to be. But of course, this is like you were saying, this case is like a complicated ball of spiders, and it's like, if they don't want to get to the Second Amendment argument, they can just pick any one of the other spiders, and they don't have to go any further, right? Mm-hmm. So they won't have to get to that point.
Yeah, and they probably won't get to the Second Amendment argument because they love avoiding that.
Yeah, I mean, the thing is, the only way they can avoid addressing the Second Amendment is by doing the right thing and freeing Matt Hoover. So, because you can't deny it without getting to it.
Yeah.
So I do really feel like we're going to prevail here, though. If I had my estimate of what theory they'd take, though, I think the one that's most obvious is the fact that the district judge,
Yes,
the district judge and the government admitted that the ATF materially altered the card. And in law, the word material literally means you have changed what something is. So I think they won't have to go further than that. But, we want to make sure that even if they have to go 10 layers down, that we do our best to, free them.
Yeah. There's a lot of arguments whether M16 is an AR-15, and M16 is the military designation for an automatic AR-15.
The M16 is the adopted version of the Colt AR-15 Model 604.
Yeah.
And I couldn't help myself but put that in the brief.
Yeah, I mean, that's I don't know why people don't accept that.
Because they've been fed this Fox News rhetoric where, no, M16 Mashigo gun, AR-15 civilian. Meanwhile, every 60% of M16s that were issued in Vietnam said Colt AR-15 on the side.
Yeah. It's not that hard.
Yeah. But anyway, but thank you guys for covering that.
Yeah, I meant to get it to earlier. It's just been so much going on.
It's been crazy.
On and off, not even gun stuff, just family stuff too. So
yeah, well, I hope everything's going good with that.
Yeah.
But yeah, no, sorry for just coming out and yapping. Is there any questions or audience stuff that I can help with?
I'm gonna get ready and go, but yeah, hold on, here we go. Will CRS have any way of getting compensated for being in jail unjustly? That is usually, what are the chances of him being compensated if he gets off on an appeal? Because I
think pretty good, actually.
You think so?
Really?
Yeah, well, if things go our way, I think pretty good. But we'll have to see. But I think the case is egregious enough that we should be able to get.
Well, the problem that I have, among 100 other things, but one, it's a victimless crime. There have been no crimes with an auto key card. Nobody has been able to get it function.
And if you remember in the case, one of the guys who testified was they gave it to me because they couldn't get it to work.
No, you were there for that day. I think the guy worked at a tool and die shop.
Yeah.
This dude knew his stuff, and he was like, I had 3 of them, and I was because the thing I kept dealing with the ATF was, how did you know where to cut? Was it on the line, inside the line? Did you obscure the line? Did you keep the line? And of course, the ATF guy goes I followed the line. But the tool and die guy goes, I tried it on the outside, didn't work. I tried it dead center on the line, didn't work. And then I tried completely obliterating the line, didn't work. And so the only one that did something is the one that, and that's the biggest thing here, is let's say, super imaginary world, right? Where it can be the case that you draw a line and it's magic. It is what it is, right? Shouldn't it have to follow the line, right? It's just so weird.
If you think about it that way, if you don't have to follow the line, wouldn't any card of metal be a machine gun since you don't follow the line?
Well, that was the funny thing. So when Toy was on the stand, we he called it a template was another thing, which all right. And so I started saying, okay, well, what if this was drawn onto, and then I started saying other things. And he was just like arbitrarily, well, I think that would be fine. And then I said, what about the steel bumper of like a Honda Accord? And he was saying, well, that would, if it was thick enough. And then they stopped me. They wouldn't let me keep going. They're like, you've made your point. So it was because I was just trying to point out how insane is this.
Wow.
They admitted that like if this drawing was on a Honda Accord bumper, that would be a machine gun. But so then what's the difference? If you don't have to follow the line, why isn't every Honda Accord a machine gun?
Exactly. Like a bunch of Cybertrucks.
Well, I think it has to at least be strong enough to function, right? So I don't think the Cybertruck would count.
Yeah. The part was intentionally drawn on the card, oversized, so it couldn't be cut on the lines. Well, it was a novelty card.
Yeah. And it was a cool thing, by the way. These things were cool. It really was a cool conversation piece. Like when I was handling them, there's one thing I really wanted is I wanted to keep one. Of course, I didn't get to. They took them all, but it's a cool thing.
Well, this was kind of a fun part. And Matt and I were both in court for this, and the judge is like, "Well, if these are so damn dangerous, how come you're not collecting them all up?"
I love that the judge recognized that and then still didn't. Yeah.
Is it Cody Toy?
The ATF agent.
That's you guys can read the filings. I don't want to be seen as being whatever.
Yeah. Okay.
People criticize me no matter what. Whenever even though Matt has asked me to talk as much as I possibly can about that, people are always like, "I wouldn't say that. I wouldn't say this."
Oh, everybody has an opinion.
Yeah, everybody's a Monday morning quarterback or whatever. But I think we're gonna make it. I think Matt's gonna be free, and I think.
All right. So if you don't mind, I'll say it. Yeah, it's Cody Toy. That didn't come from him. It came from me.
Yeah, and he got promoted.
Yeah, I know.
It's the. I gotta keep like the G-rated words on top. You only fail up in government. It's like, somebody got shot and killed, and the Secret Service was protecting people. Give me my promotions.
You're promoted to the depth of your incompetence.
Oh,
they find the extreme depth of it and then promote you to that point.
This is terrifying.
I've done a lot of work with the government, and a lot of times people get promoted out of a position because they're incompetent, and it's almost impossible to fire them. So you promote them just to get them out of your hair. I'm not saying that's what happens. I'm just saying that happens a lot in the government. I've seen it multiple times where someone gets promoted just because someone doesn't want to deal with them anymore. They're like, yeah, we're going to promote you, but you got to go over here.
I will say that Mr. Toy, I've talked to him quite a bit. He knows the stuff about guns. And so at least he didn't lie, right? At least he didn't, say it wasn't hammer follow or whatever. At least he didn't lie about the bolt carrier thing and stuff like that. So that's one thing. I mean, I don't agree with his conclusions at all, but I think the fact that he didn't lie, right, was helpful.
No, that was helpful. But I just want to thank you for coming on, and hopefully Matt can get out of prison soon and get all his rights restored.
Yep. Nope, we will be doing that for sure.
Right.
Thank
we
you.
got a cut here. Firm ammo is currency. Matt, I'm reading between the lines. If someone takes a Sharpie and draws a lightning link on a bumper, then machine guns are in common use.
Just get an electro pencil or something.
Yeah, just like engrave, just to get a little engraver, just engrave every.
It doesn't matter if it's the right size or whatever. Just take your whole fist like this. But yeah, thanks guys for covering this. I super appreciate you.
Yeah, no problem. Thank you for coming on.
No problem. See you later.
And with that, we're going to get out of here. Thank you so much for everything that you guys do. And you guys have a good weekend. I am going to get out of here.